Hi, this is Victor. Let's talk a little bit about preliminary hearings. But first, instead of describing what a preliminary hearing is, let's describe what a preliminary hearing is not. A preliminary hearing is not a trial. The defendant does not have the same rights that he will at trial, and the standard of proof is not the same. They're not trying to determine whether the defendant is guilty beyond a reasonable doubt, but instead, the judge is trying to determine whether or not there is probable cause to believe that a crime has been committed and that it is the defendant who has committed the crime. At the preliminary hearing, the defendant doesn't have the same rights that he does at trial. He doesn't have the right to confront the witnesses like he will at trial. He doesn't have the right to present all of the same evidence that he will present at trial. Instead, most preliminary hearings are what's called 115 preliminary hearings. That's from Proposition 115. That means that instead of the actual witnesses coming in to testify against the defendant, a police officer will come in and testify as to what the witnesses told him. It's hearsay. It's not allowed at trial, but it is allowed at the preliminary hearing. The preliminary hearing is not the time to put on a complete defense and prove the defendant's innocence. It's not the time to bring in your alibi witnesses. It's not the time to show that their witnesses are completely lying and then you have other witnesses to prove them wrong. Trial's the time for that. If you put on all that evidence at the preliminary hearing, all you're doing is allowing the prosecution to see what your defense is going to be at trial. The preliminary hearing is generally a short proceeding, and the sole purpose of it is to decide whether or not there's probable cause to believe that a crime has been committed and that it's the defendant who has committed the crime. Thank you.